The first question is not, can the aircraft land here? It is, what kind of import is this? Hello, this is Forrest Owens. I'm an aviation lawyer, a private pilot, and an FAA licensed airframe and power plant mechanic. In this discussion, I want to talk about aircraft import considerations in a way that is practical, memorable, and grounded in the actual rules that govern the transaction. Let's begin with the mistake that causes trouble at the very beginning of an aircraft import. People say, we are bringing the aircraft into the United States as if it were a single act. Legally, it's not. It can be a permanent import for U.S. ownership and operation. It can be a temporary import. It can be an aircraft entering for repair. It can be an aircraft entering under a structure that is duty-free under the civil aircraft rules. Or it can be an entry that triggers customs exposure, state tax exposure, and certification issues all at once. And this is why the first practical question is not, where is the airplane? Where is it flying? The first practical question is, what is the legal status, the import, and the type of import that is supposed to have? On the customs side, aircraft are still merchandise under Title 19 of the Code of Federal Regulations governing entry procedures administered by U.S. Customs and Border Protection. Title 19 CFR Part 141 sets out general requirements for entry of merchandise, and Part 142 addresses the entry process. If the aircraft is being brought into the United States for consumption entry, the importer needs a clean customs strategy, accurate paperwork, and the right tariff treatment from the beginning. And this is where many clients are surprised. In the aircraft world, customs problems do not come from dramatic misconduct. They come from category errors. A party treats a permanent entry like a temporary one. A temporary use becomes a de facto permanent presence. A buyer assumes that because the aircraft is civil, it is automatically duty-free. And these assumptions can be expensive. The tariff system still matters. Under the Harmonized Tariff Schedule, General Note 6 implements the Agreement on Trade in Civil Aircraft. The rule can permit duty-free treatment for qualifying civil aircraft engines, parts, and components. But the key word is qualifying. The exemption is not a slogan. It is a status that has to be supported. The importer must be able to show that the aircraft or article fits within the civil aircraft framework and that the entry was made correctly. Remember this, an aircraft can be duty-free and still be imported wrong. That matters even more where the aircraft is only coming in temporarily. Title 19 also allows temporary importation under bond. Under 19 CFR Part 10, Subpart B, temporary importation under bond, related Customs Border Protection guidance, goods not imported for sale can come in under bond for a limited period, generally with the expectation that they will be exported or destroyed within the regulatory time limits. That can be useful where the aircraft is entering for a defined temporary purpose. But it is not a magic parking permit. It is, if the operational facts do not match the bond entry, the structure becomes fragile very quickly. There is a related misconception in business aviation that deserves to be corrected. Entry into the United States for customs purposes is not the same thing as FAA registration. And FAA registration is not the same thing as airworthiness approval. Those are different gates controlled by different legal systems. A transaction can clear one gate and then fail in another. Practically, Import planning should therefore begin with a 4-part customs checklist. First, identify whether the aircraft is entering permanently, temporarily, or for a limited service-related purpose. Second, identify the importer of record and make sure that that party actually matches the ownership and funds flow structure. Third, classify the aircraft and determine whether duty-free civil aircraft treatment is truly available and documented. Fourth, coordinate customs treatment with tax planning and the FAA plans so that one workstream does not quietly sabotage another. This is where experienced aviation counsel, customs counsel, tax counsel, escrow professionals, and the broker all need to speak to each other before the aircraft moves. The market often treats import as a logistics exercise. It is really choreographed sequence. In short, the first segment of this analysis is simple. An aircraft import begins as a classification and entry problem before it becomes anything else. If you answer the first question incorrectly, every later answer gets harder. Here's a takeaway. In aircraft imports, the flight to the United States is transportation. The import itself is a legal characterization. FAA import approval, registration, deregistration, airworthiness, noise, and emissions. Now let's turn to the second segment of the analysis, the second layer, because this is where sophisticated parties often discover that customs clearance does not finish the job. On the FAA side, the import analysis begins with a basic rule in 14 CFR section 47.3. An aircraft may be registered in the United States only when it is not registered under the laws of a foreign country and otherwise qualifies for U.S. registration. That may sound obvious, but it is one of the most operationally important sentences in the whole process. A foreign registered aircraft does not become registerable in the United States because the buyer expects it to. It becomes registerable when the foreign registration issue has actually been resolved. Section 47.37 deals directly with an aircraft last previously registered in a foreign country. The owner must submit satisfactory evidence of ownership and satisfactory evidence that the foreign registration has ended or become invalid. The FAA's own import registration instructions may say the same thing in practical terms. The applicant needs a statement from the foreign registry showing that the prior registration has ended or that the aircraft was never registered there, along with evidence of ownership and the FAA registration application. That issue is not theoretical. In IAL Aircraft Holding, Inc. versus FAA, the 11th Circuit dealt with an aircraft that had been sold for U.S. registration but remained tied up in the Brazilian registry. This case is a vivid reminder that deregistration friction abroad can derail what looks like a completed transaction on paper. The public record in that matter is useful because it shows just how long and expensive registry problems can become when parties assume the foreign side will sort itself out. Then there's the airworthiness side. FAA import airworthiness approval guidance says the importer should receive an export airworthiness approval or equivalent certifying statement from the Civil Aviation Authority of the country of manufacture, and the United States must have a bilateral agreement with that country. For a standard airworthiness certificate on an import aircraft, 14 CFR section 21.183C requires that aircraft be type certificated under sections 21.21 or 21.29, that the state of manufacturer certify conformity to type design and condition for safe operation under the applicable agreement, and that the FAA itself find conformity and safe condition. For used aircraft, the process gets more textured. Section 21.183 requires evidence of conformity to an approved type, design, and applicable airworthiness directive, plus an applicable inspection and an FAA finding the aircraft conforms to type design and is in a condition for safe operation. In other words, importing a used aircraft is not merely a paperwork exercise. It is an exercise in conformity. And there is another point many business people miss. The FAA import rules are not limited to basic airworthiness. Section 21.29 ties import procedures to Part 34 emissions and Part 36 noise as the applicable environmental requirements. Section 21.183 also expressly incorporates noise compliance for import airplanes and bars original issuance of a standard airworthiness certificate where the applicable emissions requirements are not met. So, an import analysis that ignores noise, emissions, and related configuration status is incomplete. Here is something to take away from this. And remember, Customs can get the aircraft through the border, but only the FAA can get it into a legal operating system. That is why records matter so much. Maintenance status, AD compliance, equipment approvals, modification pedigree, prior registration, and even seemingly small discrepancies in export documentation can slow or compromise the import. A buyer that says, "We will fix the records after closing," is often saying, "We will inherit the seller's import problems after the money is moved." So the right import strategy on the FAA side is disciplined and sequential. First, confirm eligibility for U.S. registration. Second, confirm foreign deregistration or legally sufficient evidence that it has ended or become invalid. Third, confirm the type certification pathway and bilateral framework. Fourth, confirm conformity, AD status, inspection path, especially for used aircraft. Fifth, confirm the noise, emissions, and related certification overlays before the aircraft is repositioned. In short, the FAA side of an aircraft import is not a clerical afterthought. It is where border entry becomes lawful U.S. operation. Take this away. An import aircraft is not truly imported when it crosses the border. It's truly imported when its registry status, airworthiness status, and operating status all align. What the public record teaches, how aircraft import problems actually become litigation. Finally, let's discuss what the public record teaches us about aircraft imports. This third segment is where I want to make this memorable. I want to make this stick because import mistakes are as easiest to understand when we look at how they fail in the public record. The first useful example is United Technologies Corporation versus United States, decided by the Federal Circuit in 2003. This case involves the denial of duty-free treatment for import aircraft engine parts under the Civil Aircraft Agreement framework. The court affirmed the government. Why does that matter for you? Because it shows that tariff treatment in the aircraft world is not won by industry shorthand. It is won by meeting the legal requirements that support the claim. In practical terms, that means a client should never build a purchase model around probably duty free without verifying the actual basis for that treatment. The second example is a forfeiture case from the Southern District of Florida. That court describes allegations that aircraft cannons and aircraft parts had been introduced into the United States contrary to law, including theories based on missing licenses or authorizations and even smuggling related statutes. Whenever one thinks of the facts, the legal lesson is powerful. Aircraft import law is not limited to tariffs and paperwork. Importation can become a seizure problem when the article requires government authorization and the authorization is absent. A third example that's quite a bit more current is in March of 2025, the United States filed a civil forfeiture complaint against a Dassault Falcon 900EX, allegedly purchased through a nominee structure, exported from the United States under false pretenses, and operated for the benefit of Nicolas Maduro and the Venezuelan regime in violation of U.S. sanctions and export control laws. The Justice Department's public filings and announcement explain why that case matters to aircraft practitioners. An aircraft transaction that looks, on its face, like an ordinary cross-border sale can become a sanctions, money laundering, and forfeiture case if the buyer identity, end use, or service support facts are false. And there's a deeper point here. Modern aircraft import analysis is no longer just customs law and FAA law. It is also about sanctions diligence, beneficial ownership diligence, maintenance provider diligence, and payment path diligence. I want you to remember this, and I hope this sticks. Import risk lives at the seams between customs and certification, and between ownership and operation, and between the paper buyer and the real beneficiary. So, what's the practical playbook? First, define the import correctly before the aircraft even moves. Do not let the deal team use the word temporary unless the facts genuinely support temporary treatment. Second, verify the tariff basis. If duty-free treatment is being claimed under civil aircraft framework, document why the claim fits. If it does not fit, price the deal honestly. Third, lock down foreign deregistration and U.S. registration eligibility before closing. The registry problem is easier to solve before funds move than after they're gone. Fourth, run a true conformity and records review. On import aircraft, the records are not merely historical, they are proof. Fifth, treat sanctions and end-user diligence as part of the import file, not as a separate compliance memo that sits in another folder. Large cross-border aircraft deals often fail because the people handling title and certification are not talking to the people handling source of funds and end-use risk. Sixth, document the services narrative. If the aircraft is entering for maintenance, alteration, demonstration, or another limited purpose, the customs position, the operational facts, and the maintenance records should tell the same story. In short, the public record teaches that aircraft imports most often break down in one of three places: the tariff claim, the FAA conformity and registration path, or the truthfulness of the underlying transaction. And when they break down, they can become expensive far faster than most clients expect or otherwise anticipate. Remember this and take this away. The safest aircraft import is the one that can be explained the same way to customs, the FAA, to the bank, and to a federal judge. Thank you for your time. This information is provided for informational purposes only and should not be construed as legal advice. Please discuss the facts of your matter with a qualified aviation, customs, tax, and regulatory counsel before acting. Questions are appreciated, and if you have any, please direct them to admin@aviationlegalcounsel.com. We look forward to assisting you navigate these issues with precision.